Now, I'm not one to gossip, but I will bring you the tea. Welcome to Chronicle Speaks.
Please, I don't have any time for any gossip now. Eh? Yes.
Look at you.
So we got news sometime last week that Porsha Williams is making a return to the Real Housewives of Atlanta and signed an overall scripted deal with NBC Universal that will see her in scripted project opportunities across the company's broadcast and streaming properties.
Porsha Guobadia is in the building.
Now, y'all riddle me this. What's the good in adding a housewife back to Bravo's Hottest Housewives franchise without a little juicy drama coming right along with her? Now, story broke yesterday that Porsha's fairy tale life may soon be coming to a screeching halt as her husband, Simon Guobadia, is currently facing citizenship issues while being accused of alleged fraud, false identity, all while being in pursuit of chasing the American dream. Cinderella's carriage might be soon turning into a rotten pumpkin if Simon does not get this situation handled. We are going to get into this story and so much more, but before we do, please be sure to subscribe to this channel and hit the bell for notifications so you don't miss out on any news regarding this story and so much more. Now let's get back into it. So for now over 40 years, the United States has asked Simon,
do you have your passport? Did you get your shots?
Also, he can stay here in
America.
Now, Simon's most recent plea for U.S. citizenship has been turned down in federal court, citing a history of criminality and deceit. But we, the people, have been so caught up in a man finally keeping our girl Porsha happy that no one thought to check on his citizenship or even his rap sheet, to say the least. And according to the paperwork, it's pretty extensive. Simon, who happens to be a Nigerian citizen, first entered the United States on August 11, 1982. He overstayed his visitor visa, however, and in 1985, INS denied his application for adjustment of status. He was declared deportable and voluntarily departed from the United States on December 28, 1985. He then re-entered the United States in June of 1986. Petitioner again overstayed his 6-month visitor visa. In September 1987, petitioner was arrested for bank and credit card fraud and pleaded guilty to a felony offense. He was arrested in January 1989 for unauthorized use of a vehicle and again in May 1990 for fraud. Okay, so now I'm going to read this part and then we'll go back up. Petitioner's adjustment of status application in 1985 was based on his marriage, which the agency deemed a sham because of statements by his spouse that the two of them had not resided together and the marriage was never consummated. Now let's go back up. Therefore, the agency began removal proceedings. In January 1991, petitioner committed another felony offense, credit card fraud. In April 1991, an immigration judge held a hearing and ordered petitioner be deported. On March 4th, 1992, petitioner was deported and physically removed from the United States. Before his March 1992 removal, however, on October 24th, 1988, petitioner used a different identity to seek temporary resident status under the Special Agricultural Worker SAW program. He also did not include his criminal history on the SAW application. When his SAW application was approved with these misrepresentations and omissions, he was given a registration card as a temporary resident on July 25th, 1991. As part of SAW immigration benefits, petitioner's temporary resident status was automatically converted to permanent resident status following the waiting period. Petitioner received his permanent residency card on April 27, 1992, 26 days after he had been deported under his other undisclosed identity. On December 22, 2016, petitioner applied for naturalization under his second identity and was denied because his temporary resident status was unlawfully granted. On December 31st, 2020, petitioner filed another application for naturalization. Following an interview with petitioner, USCIS again denied petitioner's naturalization application. USCIS explained that he was ineligible because he had not been lawfully admitted for permanent residence. His temporary resident status achieved through the SAW program and benefits had been based on different identity and disqualifying criminal inadmissibility that was willfully concealed. Now, keep in mind that last little part was happening while he was married to Fallon, because they tied the knot on June 14, 2019, and their divorce was filed on February 19, 2021. Okay, so going back to the document, on October 24th, 2022, petitioner requested a hearing on this decision, and USCIS reaffirmed the denial of his naturalization application on November 15, 2022. On March 13, 2023, petitioner filed the instant complaint in the court and asked the court to vacate the denial and remand with instruction to grant petitioner application. Okay, and in reading further, Simon is blaming the court for not kicking him out of the United States sooner. He's not denying that he lied. He's not denying that he falsely represented himself as another person, but he's like, that's y'all's mistake for letting me stay here as long as you've allowed me to stay here, not mine. So I'm here now. What we gonna do about it? Let's continue to read. So it says, petitioner's complaint asked the court to vacate the USCIS decision denying his naturalization application and remand with instructions to grant his application. USCIS moved to dismiss petitioner's complaint because he failed to assert a basis for the court to grant his naturalization application. Briefing on USCIS motion to dismiss is complete, and thus the court must determine if petitioner has stated a claim that his naturalization application should be granted based on the information in the complaint and its attachment. As is relevant for petitioner's case, for USCIS to grant a naturalization application, the applicant must be lawfully admitted to the United States for permanent residence. It is the applicant's burden of proof to show that his entry to the United States was lawful. More specifically, applicant must have been a lawful permanent resident for the last 5 years, reside in the United States continuously between his naturalization application and admission to citizenship, and be a person of good moral character attached to the principles of the Constitution of the United States and well disposed to the good order and happiness of the United States. Here, USCIS denied petitioner's application because he failed to show that he was a lawful permanent resident. Petitioner's permanent resident status arose from his application for SAW immigration benefits in 1992, indicating that through the SAW program, petitioner first achieved temporary resident status, which was automatically converted to permanent resident status after the relevant waiting period. Okay, let's jump down to the bottom part and then we'll go back up. There are also specific requirements for an applicant's continuous physical presence in the United States during this 5-year period that do not appear to be an issue in petitioner's case. Second part, the agent's factual record consists of government records and an interview conducted with petitioner himself discussing government records and petitioner's own statement. As indicated, USCIS factual determinations regarding petitioner's SAW application have not been challenged in petitioner's instant complaint. Let's go back up. The factual record, however, shows the petitioner's SAW application had been based on a number of misrepresentations and concealments by petitioner. Specifically, petitioner's application for SAW benefits under a different identity. Number 2, misrepresented his marital status. Number 3, improperly answered no to the question of whether he had any prior arrest or convictions. Incorrectly answered no to the question about whether there was any factual basis that made his inadmissible under 8 USC 1182. Given his criminal history. And number 5, misstated the date of his last entry into the United States. Review of petitioner's application following request for a hearing reaffirmed this decision and its reasoning. In this lawful requirement, the United States de novo review of the USCIS's decision, petitioner importantly does not dispute these factual findings. He does not contend that either USCIS's account of his testimony or the government records were incorrect. Instead, petitioner contends that the USCIS misrepresented the significance of the misrepresentations on petitioner's SAW application. The court treats these complaints, allegations, and its attachments, which includes the USCIS decision, accordingly. Petitioner first argues that he should be granted naturalization because Immigration Services has not raised any concern about petitioner's permanent resident status for 3 decades. Indeed, until the petitioner's naturalization application, no immigration official has contended that he was anything but a personally lawfully granted permanent resident status. Petitioner then argues that he should not be made to bear the burden of the government's mistakes. He argues that the appropriate remedy for the issues regarding petitioner's SAW application would have been to terminate his temporary resident status, and he should not be denied naturalization now. This is where he goes on to say it's their fault. INS had been afforded ample opportunity to revoke or terminate his temporary resident status, and having declined to do so, it lawfully admitted petitioner to permanent resident status. The service may not raise its own lack of action as a ground to deny petitioner citizenship. Now, the court finds petitioner's argument to be unpersuasive. Preliminarily, the court rejects the suggestion that USCIS is at fault for not discovering petitioner's own misrepresentation and omission. Petitioner, in essence, asked the court to allow USCIS's previous treatment of his immigration status to ratify his unlawfully obtained permanent residency. The court refuses to do so. To be sure, it is the petitioner who unquestionably holds the statutorily imposed burden of proof to show his eligibility for naturalization. The court does not find that this burden is carried merely based on the agency's erroneous treatment of petitioner's status following his own misrepresentations and concealments. Moreover, petitioner lacks any legal support for his argument that is an operation of law. He achieved lawful permanent resident status by the agency not previously having corrected his status, which again was only granted given his own misrepresentation and omissions. To the contrary, legal authority suggests that achieving permanent residence through an unlawful means is a basis for denying naturalization. And they gave several case law studies. Kayla versus the Attorney General of the United States, an application for permanent residence containing material misinformation fails to conform to substantive legal requirements. In this instance, a naturalization petition was denied properly because the application for permanent residence misrepresented critical facts. Then they go into another case law study, but we're going to skip that and jump to this part. Thus, the court rejects petitioner's argument that he is in fact a lawful permanent resident based on his SAW application. Petitioner also argues that the statements in his SAW application, whether fraudulent or not, cannot be used against him to deny immigration benefits because of statutory confidentiality protections afforded to SAW applications. The court concludes the petitioner's argument misses the mark. USCIS did not deny petitioner's naturalization application based on protected information in his SAW application. USCIS denied his application based on its own investigation during the petitioner's naturalization application process. Not only does this investigation provide an independent source for this information outside the SAW application itself, but federal regulations allow for using prior immigration records in the process of assessing a naturalization application. Information contained in granting files may be used by a service at a later date to make a decision on a naturalization application submitted by the applicant. Hence, USCIS's decision did not improperly implicate any confidentiality information protected under statute, and the information contained in the SAW application can be used instantly to assess if petitioner states a claim for naturalization. Based on petitioner's complaint and the attachments therein, the court concludes that a petitioner's permanent residency for purpose of his naturalization application depends on his permanent residency status achieved from his SAW benefits. Petitioner achieved his SAW benefits through misrepresentations and omissions regarding his identity, criminal history, and other personal characteristics, and thereby petitioner's permanent residency status is not lawful for purposes of granting his application for naturalization. Without lawful permanent residency status, petitioner's complaint fails to state a claim that he meets the eligibility requirements for naturalization. No person shall be naturalized unless he has been lawfully admitted to the United States for permanent residence. Conclusion: for the foregoing reasons, the court grants USCIS's motion to dismiss and dismisses petitioner's case. So this was dated January 11th, 2024. Simon pretty much was like, look, I'm not denying what I lied about or how I went about lying about it. However, the information in my SAW application legally cannot be used against me. So therefore, you can't deny me access to live here in the United States. And they were like, wait a minute, Playboy. We didn't even use your application. We used our own independent investigation and found out that you were fraudulent without even having to go into your application. So get out of here, Simon. So the Neighborhood Talk posted this story last night, and an immigration attorney got in the comments, and she said immigration law is incredibly complex and not that simple. This agency makes mistakes all the time. They mix up files and make reckless allegations. You absolutely cannot conclude that he is done without a diligent and complete review of the record. Analysis analysis of the allegations and the relevant INS sections at that time. The law has changed in several parts over the last 30 to 40 years. I would fiercely defend this client against deportation if we have a path. There are lots of waivers he may or may not be eligible for. Our law firm would have done a complete FOIA, Freedom of Information Act request, reviewed his entire immigration history before filing citizenship, and if these are true, advise not to file. We advise clients all the time to sit out naturalization proceedings after reviewing their record. All this notwithstanding, the government may still not move forward with removal proceedings, though very unlikely. Simon is on Instagram smoking his cigars and smiling, and his caption says, "Ide campe, no shaky." And from what I found on Instagram, it means I am doing well, no problem. Y'all have to correct me if I got that wrong. Other than that, Simon doesn't seem too concerned about it, and neither does Porsha. I honestly think this is part of the storyline, although it's a real situation. The fact that it's just now coming out and it's been going on for all of these years, definitely a storyline. What I need you to do is leave a comment. Tell me what you think about all of this going on about the deportation, honey. Leave a comment, and you know how we do. We'll talk about it down below. Talk to you guys later. Bye. As always, thanks for watching. Don't forget to hit that subscribe button, hit that like button, and hit that bell so you don't miss any of my new episodes.